First, thank the House Committee on Delegated Legislation for bringing this bill, which I support, Honorable Speaker, save that I would be proposing a few amendments to the very provisions proposed in the bill to make it work better. Honorable Speaker, delegated legislation, as called, whether you call them subsidiary or subordinate legislation, derive from the fact that under Article 94 of the Constitution, the legislative authority of the nation is granted to Parliament. And so the primary legislative authority is with Parliament. Parliament, in most cases, will legislate directly. In other cases, Honorable Speaker, Parliament will delegate that legislative authority to other bodies, especially within the executive. And the reasons for delegated legislation, Honorable Speaker, is that number one, Parliament deals with a myriad of issues. So as a house in charge of legislation and other roles under Article 95 and 96, in terms of the respective roles of the two houses, we seldom have time as Parliament to give all the details you need in a legislation for the good governance of the people. And so that, Honorable Speaker, you walk across virtually all bills, if not most of the bills we pass as Parliament, you will get provisions delegating the power to make laws, which is initially invested in Parliament, to various regulation-making authorities, whether in the executive or in other bodies performing administrative functions. At times, Honorable Speaker, we are also faced with paucity of time. At other times, Honorable Speaker, Parliament is said not just to lack time, but the expertise, technical expertise, which may be needed for expeditious implementation of the various laws we make. And because of that, Honorable Speaker, Parliament will bear with skeletal frameworks, but provide for rule-making authority in other in other bodies. Honorable Speaker, because Parliament is the delegate, Parliament must supervise the exercise of that authority. And this is the reason as to why I find this bill not only timely, but useful. Parliament, as the body in charge of delegation, as mandated by the people and the Constitution, must always check to ensure that these various laws being generated by various regulation-making authorities on powers delegated or donated by Parliament, Honorable Speaker, are applied in a manner that is consistent with the law, in a manner that is consistent with the parent law, and in a manner that is in consonance with our values in terms of principles of governance. Honorable Speaker, it is therefore not acceptable, in my view, that a regulation-making authority can just make regulations and keep the regulations with themselves somewhere. Unlike parliamentary bills which we have here, Honorable Speaker, every day. You know, bills, we go through the first reading, the whole citizenry will be informed there is a bill on this and this coming, including members of Parliament. We go to public participation at the second stage, and of course they'll still be told this and this is coming, what are your views on it? Delegated legislation, Honorable Speaker, Madam Speaker, does not have that benefit. They are generated in executive offices and within the offices of the regulation-making authorities. We, as Parliament, enacted the Statutory Instruments Act. And Honorable Speaker, I want to thank this Parliament and the membership who sit in that committee for electing my good friend, the Honorable Samuel Chepkonga, to chair this committee this time. I know in the other Parliament we had Honorable Murugara, the Deputy Speaker herself chaired this committee on delegated legislation when times were favorable and good before changes occurred. I remember, Honorable Speaker, you had a very good friend we miss in the House who was a nominated MP, who was also very zealous about this matter. But we worked with Honorable Samuel Chepkonga in the Committee on Justice and Legal Affairs before. And I can assure the House that when a committee chaired by Honorable Chepkonga or Honorable Chepkonga as a person brings or proposes legislation to this House under his hand, it is something he has considered. I therefore support this because it does not just strengthen parliamentary supervision of the exercise of the power Parliament has delegated to those other bodies, which are proceeding with not much publicity in most of the times, which are proceeding without public participation most of the times, because it is only Parliament which is required to engage on that. This bill, Honorable Speaker, will secure that we have a leash on these bodies regulating authorities. And Honorable Speaker, when you look outside there, in fact, before this committee was enacted and the Statutory Instruments Act also got enacted, Honorable Speaker, there are just so many regulations, so many orders, so many rules, so many commissions, so many directives issuing outside there which fall within legislation and affect the governance of the people in terms of being part of the body of a law without notice. Honorable Speaker, that takes me therefore to clause 2 of the bill, and let me say something very briefly on them, having justified the need for the bill generally in terms of improvements which need to be made. Honorable Speaker, at subsection 5, it says that the committee shall require regulation making authority. Honorable Speaker, I find this to be superfluous. If not superfluous, I find it to be redundant. And I'm sorry to use the latter word. Superfluous because this Parliament, either as a House or through its committees, already is mandated by Article 125 of the Constitution to require anybody that is under its charge, whether in the plenary as a House or as a committee, to submit and to do whatever the House will do. And in those rare cases which fall under Article 125, Honorable Speaker, you have situations where Parliament can even summon these bodies. So I don't think it adds anything, I may be corrected, when we say the committee shall require. The committee already has the capacity in law, is empowered in law to require if they are minded to do so. And so I don't see the value of this provision unless in continuing deliberations and debate, it will be explained that this is going to add. Honorable Speaker, at the proposed 2.6, it is being proposed that if there is failure, then the committee will publish in 2 newspapers of wide circulation a notice confirming that, of course, the regulations that they are dealing with in this context no longer has effect. Honorable Speaker, 2 or 3 issues. Number 1, these delegated legislations are laws, save that they are made on delegated authority. As a matter of parliamentary practice, only laws which are already made are published, and they are published in the Gazette. You don't publish law which has been nullified. And even if or where you are to publish rejection, and I ask Honorable Chepkonga to get me on this, because I want to support, but allowing him to improve. Whether you publish rejection or revocation or annulment of a law, or the existence of a law, the document for that publication is not the newspaper, but the government printers, the Kenya Gazette. So I would be requesting Honorable Chepkonga that the fact of nullification, revocation, or rejection of a statutory instrument, and I would beg this be implemented, goes to having that fact published, not even the entire body of regulations, but just within the Gazette notice indicating, because it is the only official public Gazette, you indicate such and such regulations promulgated by such regulation making authority has been revoked for the area of law to be cleansed. And I believe that would be neater. Number 2, Honorable Chepkonga and the members, I think it will save costs on
don't have a mic.